Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the extra mile when you're studying for your bar exam. And now your hosts, Jackson Mummy and Megan Saya from Celebration Bar Review.
Hey everybody, welcome. Hi Megan, how are you?
Hi, doing well. How are you?
I'm doing just fine. I just had to look at my clock to see where we were in October. I'm so lost. This is so strange to be back in a regular schedule where we get this time between bar exams. It feels weird, doesn't it?
It does, but it feels lovely to actually have some space for sure. I'm sure the students are really appreciating that as well. I'm hearing from people that it's nice to not have to jump right back in for people who are retakers.
There you go. We're excited today because we're doing the second in our series called Anatomy. It's not Grey's Anatomy. It's Jackson and Megan's Anatomy. But we're doing Anatomy of the law paragraph in an essay, right?
Yeah. How to walk through what do you do when how can you approach the law paragraph? How can you figure out the arguments? How do you piece it all together? Yeah, I'm excited. I think it's going to be really helpful for people.
Yeah, we are excited about it and hope you'll stick around for that. And we're also going to update you on bar results and information around the country as we've gotten it in. We're still in an interesting period in which we've not heard from a lot of big states, haven't heard from New York, haven't heard from California, Texas, Georgia. So we're still in a strange lull period. Although my spidey sense says, I'm going out on a limb here, my spidey sense says New York and Texas in the next week should be coming in. So we'll see if I'm right about that. In any event, where do we want to start today? We're going to talk about results first?
Yeah, so not a lot of news in the results world. I believe Minnesota just came out today. But again, we're still waiting on the big ones, right? We're still waiting on Texas, California. Obviously, we know that. Georgia, New York, New Jersey. So yeah, starting to definitely, we've had a lot of the smaller states trickle in. But we're in Florida being the one big state that we've heard from. But yeah, waiting still on those. What's really interesting, though, is that for the first time in at least as long as you or I can remember, the NCBE has actually published the repeat bar taker pass rates for each individual state. So Jackson, you want to talk a little bit about what we're seeing there? It's really interesting, right? That we often do the work, but that they broke it down to show what do the retake pass rates look like for each jurisdiction. So
this is the first time I can ever remember them actually formally publishing in real time the repeater rate. And I think what it's really showing is that there's this enormous dichotomy between the first time rate and the repeater pass rate. I'm looking at Alabama as an example. The first time pass rate was 72%, but the repeat pass rate was 15%. That's staggering. If we go to Connecticut, 75% first time rate, 14% repeater rate. When we get to Florida, this is really interesting. Megan and I were talking about before we went on air. We did our own statistical analysis because Florida does not officially release a repeater rate to the public. And we estimated a 22% repeater pass rate. It's now come out publicly from the NCBE, and it was 21% for repeaters, 72% for first-time takers. Now, so I feel vindicated, but I wish I had been wrong. I wish that number had been higher for repeaters, but 21% repeat bar taker rate. So 1 out of 5. And we're seeing that 20 percentile all across the country. I won't take you through every jurisdiction, but we've got a fair number of jurisdictions whose repeat pass rates are under 20%, some as low as 11% in the state of Washington, and a couple that are high. And I think it's important to point out in South Dakota, the repeater bar pass rate was 91%. Now, that doesn't mean you should all run to South Dakota. It just means they only had a couple of people and they both passed. I think that what we're seeing is that there's a greater awareness of what's happening, this split between the haves and the have-nots, if you will. And it makes it pretty clear to me that if you're a repeat bar taker, the days of being able to just wind it up and go in and say, this time I'm going to get it, are really coming to an end. Don't you feel like that?
Yeah, I think the truth is they've been done for a while. but the numbers really look different when you see, if you see a place and it says, let's say Connecticut, 59% overall pass rate. So you think, oh, Connecticut is just really hard. It's just a really hard bar. But then when you see the breakdown and you see 75% of first time takers passed and only 14% of repeaters, you realize it's not even that they're being that tight on the exam itself. It's that if you are a first time taker, odds are really in your favor. And if you are not, if you're a repeater, they're really not. And so, of course, the examiners and the graders don't know. I'm sorry, the examiners know. The graders don't know that you are a repeater, right? So that to me says there is something about, which this is not coming as a surprise to Jackson or myself. There is something about people who have failed the bar. They're missing some component piece, at least one component piece, about understanding how to take this test or how to study for this test or how to represent what they know on the page. And so that is not going to magically disappear for you, right? If you're a repeater. That what we're seeing with these stats is that if you have failed it once, you are in most places pretty statistically likely to continue to fail. And so to me, that says you need to change something and do something dramatically different than you maybe started out doing.
Yeah, it is the great frustration to me to see people fail the exam repeatedly and they refuse to change. Whether they're in our course or they're from somewhere else, you just can't keep doing the same thing on this bar exam and expect a different result. It's statistically almost impossible for that to happen. So when I see the people who have been successful, who are repeat bar takers, it is almost always the person that added photo reading, or they got coaching help, or they came to our course for the first time from a big box or another tutor. And in those situations, they pass. And when they pass by a lot, it's not like they just squeeze over. We see some extraordinary jumps in scores. So it is possible to do this. But I know that for so many bar takers who are repeaters, two things happen. One is they emotionally get beat. They're defeated. And because they're emotionally defeated, then they start feeling financially defeated. They feel a lack, right? I don't have enough, and I don't have enough money, and I don't have enough time, and I don't have enough of all the resources that I need. And then they just give up. Look, sometimes it's better to just take a pause, which is why we don't require you to sit immediately for the next exam. We give you a lifetime pass guarantee. You can defer as often as you want for as long as you need to, in order to muster your resources. Get your money together, get your time together, do the time coaching with Brianna, do what you've got to do so that you can actually make a difference when you study. Yeah, you can keep taking anybody's course that will let you and just do the same thing, but these numbers are making it abundantly clear that doesn't work. And so when we have students who succeed, and we have plenty of them, and we focus almost exclusively on repeat bar takers, so this is where we live, we know it's because somebody did something different. And I just cannot reinforce that enough. When I do the videos for people that have failed, I say, please do something extra, do something different. And if you're not willing to do that, pull away from the exam till you're ready, because there's no, I don't know, do you think there's any real value to going and getting your head kicked in on a regular basis twice a year?
No,
it doesn't seem like a good plan. So we're glad to help you. We want to help you plan it and figure it out. That's why we're here. We care very much about that. And I want to leave people, when we talk about results, with hope. We see people pass every exam, every year, who have these amazing stories. And I sometimes I feel like I'm really pushing people to tell their stories. And it's so hard to get folks to come on and tell a story when it's been so painful and difficult. So I'm very appreciative for everyone that does. But I just want you to know there are lots and lots of people who have been where you are, and they got through it, but they did it when they did something different. And so it is possible. You just have to be willing to make the commitment.
With all that being said, let's jump into just a couple of quick questions, and then we will get into study strategies and our sort of lesson for the day on bar essays.
Yeah.
All right. So first, I'm fairly overwhelmed with the length of the lectures and would like to see a shortened outline. Is there one?
Yeah. Part of this is a paradigm that's based on Convisor, right? The mini outlines, right? People get it locked into their brain that that's how it works. We have, again, a very different approach. Our lectures aren't any longer or shorter than anybody else's. You can break them into smaller pieces, but generally they're all pretty manageable. And the entire course, from start to finish, regardless of what state you're in, takes about 250 to 300 hours, which is dramatically less than a big box course. Most of those courses are 500 to 600 hours. So we're 250 to 300, so dramatically less. So start with that as the premise. The second thing is that under the new course platform that we're using, you can see everything that's there, and you'll see a number of assignments or lessons that say optional. If you're feeling rushed for time, and there's no reason for that to occur today, but if you are feeling rushed for time, you could skip the optional assignments unless they speak to you in some way that you think is important. So if test anxiety and stress isn't really important, you skip that entire unit, it's optional. But I think what you'll discover is that if you just go along assignment by assignment, you'll be fine. And each assignment, we identify how long the lecture is and the reading that you need to do or the question practice. And it doesn't take as much time as people expect it does. What we learned by moving off of a regular syllabus to this study structure where it's all on the screen for you is that you can see the whole package, right? You can see where you're going, and you can see that at the end there's a lot of review. So as you go through the course, it's going to show your percent complete, which is cool, I think. But also you can just get a feeling for pacing that you're going through. And my recommendation to people right now would be about 15 to 20 hours a week of study. Does that sound about right to you if you're taking the February exam?
Yeah, definitely.
And I think at 15 to 20 hours a week, you're going to have plenty of time to get through everything. So the answer is no, there's no shortened version. You could make your own, you can create your own journey, but you really don't need to. If you just follow our path, you're going to be fine, and you have plenty of time. This might be a slightly different conversation if we were having it in January or February, right?
Yeah, of course. One quick study strategy question, and then we will hop into the anatomy of the essay. Occasionally, I get the temptation to want to write using IRAC even after I have gotten comfortable with the FLA method. The reason I get that temptation is because when I write the facts in the first paragraph, it seems as though I'm just restating the facts, although I know the reason is to set the factual framework of the dispute.
Yeah. You want to start with that and I'll pick up? You want to?
Yeah, I'm not really sure what this person is asking or saying the problem is. I think certainly it's a common temptation to write IRAC because that's what you learned in law school. That's what, as most of our students are retakers, they learned to initially to write for the bar IRAC. We're going to talk a little bit about today. There's a lot of different ways to approach bar essays. So FLA is not the right way and IRAC is the wrong way. But certainly I think that we find that just like we're talking about the doing something different, I think what helps people get out of that mindset of maybe I'll fall back on that is if writing IRAC did not work for you, it's not necessarily going to magically start working for you. So that's why we try to give people an alternative path to writing essays that I think makes a lot more sense and is a bit more clear and intuitive than IRAC. But the worst thing you can do is do a hybrid. Please don't do that. Don't try to walk the tightrope. It is very stressful for you. It will probably lead to a really messy, disjointed essay that's not going to be very successful. So this student is not alone in feeling, maybe I should go back. It's the devil I know. It just feels more comfortable to stick with what I know, even if it hasn't been working terribly well for me.
Yeah, and in the course platform under the essay writing unit, there is an optional lesson called FLA versus IRAC. It's a pretty good look at why we think this is a better writing style than IRAC writing. I don't know that there's any relationship between IRAC writing and writing about facts. I guess IRAC writers don't use facts at all. I think the facts make a big difference. In a later session, you and I are going to do anatomy of the fact paragraph. That's not our topic today, but we'll talk about why facts matter so much in our writing style. But I think if you're feeling like you should be an IRAC writer, my question would be Megan's. How'd that work out for you in the past? And the odds are it didn't work so well. And I know there's a lot of pressure that people feel like everyone uses IRAC. Everyone uses it, but you've just seen what the results look like. And for repeat bar takers, everyone using IRAC doesn't work very well. So I would be very skeptical of that. It is not the golden ticket by any means. It's not a bad way to write. I just think there are better ways. So check that out and we'll go there. So, all right, cool. We're really excited about this. This is the second part of our discussion of anatomy of an essay. And what Megan and I are going to do today is, again, to take you through an actual bar essay. And today what we want to do is look at the second paragraph in the FLA writing style, which is the law or the legal argument discussion. And we want to discuss how you can actually put together that second paragraph. Now, remember, last week we talked about the anatomy of the answer overall, and we talked about the importance of kind of keeping your cool and breaking it into different sections. And today we wanted to get a little more granular and look at this second paragraph. So what I'm going to do is start by reading you an actual essay question from the Uniform Bar Exam, but really what we're talking about applies to all jurisdictions. And I want to read it to you, and we'll just take one paragraph per screen. So if you're listening, you can keep up with us. If you're watching, it's pretty easy. So here we go. A police officer on routine traffic patrol watched suspect drive by. Suspect was in compliance with all applicable traffic laws except the state seatbelt law. The state motor vehicle code provides that police officers have discretion to make an arrest for any traffic infraction, including the violation of the state seatbelt law. Officer had never stopped a driver merely for violating the seatbelt law. However, officer knew that suspect was a reputed drug dealer and stopped suspect's vehicle, hoping to uncover evidence of a more serious crime. Now, this is a good place to just stop and say, wow, there's a lot of facts there, aren't there? There's a lot going on that starts to set up some arguments in your mind. Megan, did it prompt any arguments for you?
Oh, yeah, you should definitely be thinking as you're reading through stuff like this, okay, we've got compliance with all applicable traffic laws except for a state seatbelt law. That should ring a couple bells. You might not know what you're doing with that yet, but you're like, okay, he did violate a law, so we know that's going to happen. And then they give you the state motor vehicle code. I think also I would have some alarm bells about, we have a state motor vehicle law and a state motor vehicle code. So we have to keep those in mind. And interesting officer had never stopped a driver merely for violating the seatbelt law. That's interesting, but it says that he can do that, even though he hasn't before. And then, of course, the suspect was a reputed drug dealer. And then they give you the officer's state of mind. What was the real reason for the stop, right, in the officer's mind? So definitely I think that any of you probably saw all those things as well.
Yeah. Every sentence of that paragraph mattered, didn't it? There was no fluff. There was no missing stuff. So for those of you that think, facts, we were just talking about facts. The facts matter. Yeah, a lot. Let's see what happens next. Officer directed suspect to get out of his vehicle, handcuffed suspect, and told suspect that he was under arrest for violating the seatbelt law. Immediately afterward, officer looked through the driver's side car window and noticed a clear plastic bag containing white powder on the front seat of suspect's car. Officer asked suspect, "Are those drugs yours?" And suspect responded, "No, that cocaine isn't mine." You gotta love it. Officer then opened the car door and removed the bag of white powder. All right, so what we've got now is the stop has occurred, there's a handcuffing, and he's under arrest, and that's the end of the traffic. That's the end of the stop. But then we've got something new happening, right? So we get this time lapse of immediately afterward. And now, Megan, we're turning to another problem, aren't we, in the rest of this paragraph?
Yeah, certainly. So that should definitely stick out to you that we had just the traffic stop. Now we've got suspect under arrest, which should just be a flag, of course. We have different rights when we've got someone under arrest versus just a traffic stop. And then we've also got now this search of the car.
Yeah. And this is going to presumably be important whenever we see drug stops and something sitting in somebody's car. That's pretty much a trigger to say, hey, something's going to happen around that. Okay. Next paragraph of our question says, officer transported suspect to the police station for booking. Detective visited suspect in the police station holding cell to attempt an interview. Detective read suspect his Miranda rights. Suspect stated that he understood his Miranda rights, but nonetheless would answer detective's questions. Suspect voluntarily answered detective questions for 5 minutes and then said, "I'm not sure about this. Maybe I need a lawyer." Detective did not seek clarification of suspect's statement, but continued to question suspect, who ultimately confessed to possessing the cocaine found in his car. Let me tell you why I got confused there for just a minute. And that is because so much happens in that previous paragraph that's implied. Remember, the suspect says, "No, that cocaine isn't mine," which would be a voluntary admission, wouldn't it? And I was thinking of something else, but it's pretty clear at that point. Was he Mirandized? I don't think so, not in paragraph 2. But the Miranda warning comes in paragraph 3. Is that problematic at all for you, Megan?
Oh, yeah, certainly we're going to talk about that later on, that there's a lot that this brings up here, right? So we've got the transporting to booking. Again, we have a different situation than we had when it was just so now the suspect is arrested and in custody. And then we've got the trying to interview someone, right, different on the side of the road than it is someone who's at the police station. So yes, definitely there's going to be a lot to dig into with these pieces.
One subtlety here is you notice at the beginning of this paragraph, we've got the officer, someone named officer transporting the suspect, but then someone named detective visiting the suspect. That's a real subtle thing, but it's very important in this question. So don't read over that. Don't think officer and detective are the same person, right? They've got different names. So clever of the examiners. Okay. Next is setting up the problem. The state charged suspect with misdemeanor violation of the seatbelt law and felony drug possession. Suspect has moved to suppress all of the state's evidence, alleging an unlawful stop, an unlawful arrest, an unlawful seizure of evidence, and multiple Miranda violations. Now, this paragraph is really important. And if you go back to last week when we were talking about the anatomy of a question, this is the paragraph that helps you line out where the disputes or the conflicts or the issues are going to be. Wouldn't you agree?
Yeah, definitely. I think it's really helpful. They don't always do this, but this should be as much, in my mind, your roadmap as much as the calls of the question. Because, for instance, they tell you multiple Miranda violations are alleged. So you need to know in your head when you see something like that, I need to make sure that I've answered them all the different Miranda violations, potential Miranda violations here, and not just focus on one.
Yeah. And we wanted to do this because it's a little bit of a review of what we did last week, but I think it's important when you get a question that tees up the answer, don't jump over it, right? Take advantage of what they're giving you. This is a real live essay question. This is what the examiners do. When you see it, use it. Okay, so now we get to the actual call of the question. And you'll see that there are 4 specific calls of the question, and I'll read them to you. The first is, did the traffic stop and subsequent arrest violates the suspect's constitutional rights? Number 2 is, did the officer's seizure of evidence from suspect's car violate suspect's constitutional rights? 3, did officers' questioning of the suspect violate the suspect's Miranda's rights? And then 4, should suspect's confession to detective be suppressed? So again, you see the difference between officer in question 3 and actually in question 1, question 2 and 3, and then question 4, we've got detective. Any comments about the call of the question?
I think it's just obviously when we talk about, use these to set up what you want to talk about, and then make sure within each of them that there isn't anything, as we talked about last week, that there aren't any other sort of subsections within them that you might need to talk about. So, for instance, that 4th one was, should suspect's confession to the detective be suppressed? In order to answer that, you probably actually need to pull out 2 separate pieces, right?
Yeah. And so even though they don't explicitly ask for a 4A and a 4B, I think you're going to need them because there's really 2 different parts to the confession. We'll get to that in a minute. So that's what we've got in the question. And at this point, as you're looking at it, again, you may be saying to yourself, I'm sorry, what? What's going on in this question? It's just not as difficult as people want to make it. And that's why we wanted to point out how you can tee this up. And my hope is that based on what you learned last week about the anatomy of an essay question, that as we went through this question this time, hopefully it felt a little more comfortable to you to analyze it before we ever got to the writing piece. That's my goal, is that it would have looked simpler to you this week than last week, because now you have an idea of what you're looking for. So again, even though you may have that moment of panic, don't let it throw you.
Definitely.
All right. So now, what are we going to do? We're going to pivot now a little bit, and we want to dig in from here. Having set up the question, we now want to analyze the different kinds of arguments that get made in a bar essay answer. And we chose this question because it demonstrates 3 different types of argument structures or styles. And that'll make more sense to you, I think, as we go along. But when you think about arguments, I want you to picture in your mind that the 2 parties are sitting in front of you, and you're like our person there in the picture that's looking between 2 different people and trying to hear the arguments of both sides. What is it that's going on? What is their position? The purpose of a bar essay is not to reach a conclusion, in my view, so much as it is to show your reasoning and how you use the law. And the way that you do that is by identifying the arguments and the law that support them. And what we've discovered over the years of teaching in this format, and this is something that I helped develop back at Georgetown more than 30 years ago, and Megan's been teaching for over a decade now, and we've been utilizing successfully at Celebration Bar Review for years and years, is that there's a form of writing in this law paragraph, in our FLA style, that lets us dig in to different kinds of arguments. And we want to show you these different arguments based on this question and how you actually compose them. So anything you want to add to that, Megan?
No, go for it.
Okay. All right. When we've got these 3 forms of arguments, I want to break them down for you. And if you're taking notes, this is a good thing to take notes about. The first style of argument, and we're not talking about this particular question, but in any essay answer that you write, argument style 1 is in which each of the 2 parties has a separate and distinct argument, and each part of the 2 parties is going to rely on a separate and distinct rule of law. In other words, party A has got an argument and a rule of law that they rely on to support their argument, and party B has a separate argument and they rely on a different rule of law. This is the most common form of an argument. It's the one that you'll see in most of the questions, but not in every call of an essay question, right?
Yeah, definitely. This is the one that if you've done the personal writing workshop with me, if you've done coaching with Jackson or myself, this is what we're teaching you to do all the time, because this is what you're going to see more than anything else, certainly.
Yeah, and it carries most of the weight. When you get these kinds of arguments and law, this is going to be a big part of the answer. It's not a 10% or a 5% part of the answer. Typically, it's a bigger one. All right. Now, the second form of an argument is this. Each party A and B has a separate argument, but they're both using the same rule of law. In other words, party A has an argument and it's supported by a rule of law. Party B has a distinct argument, but they agree that the law is what party A has said. In other words, it's the same rule being used by both parties. What's that going to turn on then? How you interpret the law in this situation. And this causes confusion to people sometimes, doesn't it?
Yeah, definitely. And there's a few different ways to approach it. So we'll talk about that when we get there, that you and I both have a slightly different view on how you can do it, which is really just comes down to then what makes sense for you all as writers.
Absolutely. And so we want to make the distinction, though, it should be pretty clear at this point, that argument type 1 is different than argument type 2, right? Now we're only talking about one rule of law in argument type 2 instead of 2 rules of law. So keep that in mind. All right. Our third form of an argument is very simple. There's one party and they clearly win. This is often a transactional piece, or it's a rule-based piece. It's something in which party A has an argument and the law is clear and they win, and there's really not an argument on the other side of the dispute. There's hardly a dispute there at all, and it seems like it's more just pro forma, or it's just sort of saying here is the obvious outcome. But we don't see that very often, do we?
Right. It's definitely not something that people should be. If you find yourself writing and doing this often, where you're like, oh, the other side doesn't have any counter argument against this, you're probably missing something. So this should be used very sparingly. It's generally going to be in a question where there are a lot of calls of the question or a lot of conflicts. And it's also going to be, generally speaking, by far the least important part of the essay answer. So it'll be maybe worth 10% or 15% of the grade on that question. So you really are spending a lot less time on it, but it's because it's pretty straightforward. It certainly should not be make up the bulk of any essay question and any essay answers. And it's also very often that you will have no answers like this whatsoever, where you just have one clear winner and that's not even an argument to be made on the other side.
Yeah, if your answer has got nothing but argument 3 types, you're in trouble. that just doesn't exist. So be aware, we're calling them 1, 2, and 3 because that's the frequency in which you're going to see them. All right, now, what we want to do is, obviously, we don't want to make this more complicated than necessary. We've just shown you the 3 argument types. Now we're going to demonstrate them in this question. We're not going to answer every part of the essay, but we want to use this essay because it did have all 3 argument types available to it, and we wanted to demonstrate those. So if you're feeling a little confused about what they look like, we'll get into it. So let's talk about the argument flow, and by the flow, I'm following it step by step for our type 1 argument. And we're going to use an actual argument from this. In this flow, remember in type 1 flow, we start with party A's argument. And you might say, who's party A? Well, you've got 2 parties typically in a problem or in a dispute, certainly. And party A could be either party that you want to start with. I like to start with the party that I think is advancing an argument, because for me, it just makes sense. You'll see in a minute, Megan's got a slightly different take on this. But it doesn't really matter. You could start, I'm calling party A in this problem the suspect. And I'm talking about the traffic stop question here and the argument that the way that I would describe it or write it. And so my argument for party A will be, suspect would argue that the traffic stop was pretextual. In other words, nothing really was done wrong. That's party A's factual argument. Now notice I'm not using any law here. I'm just putting the argument in first. And typically this would be a single sentence, and it would be the way I begin paragraph 2 of my answer to this traffic stop question. So that's party A's argument. And Megan, feel free to jump in anywhere here that you want. All right. Then the second part of the flow is, after I've made the sentence of party A's argument, I now want to talk about the law that I think supports that argument. So party A's law, if you will, which for me here is that the 4th Amendment prohibits warrantless stops. And I could be more, I could go on longer, I could say more about it, but for our purposes today, I just want to give you an essence or a paraphrase of the law. So my argument is, hey, this stop was pretextual, and the law is that the 4th Amendment prohibits those kinds of stops. So at this point, I have an argument and a law, right? Make sense?
Yes.
All right. Now, in type 1, we now, in the same paragraph, flip to the second party's argument. So now party B is going to be the officer or the state. And their argument around the stop would be that state law permits stops and arrests for traffic violations. You remember that from the first paragraph of the question itself. So this is party B's argument in response. So again, I'm laying it out. I'm now up to my 3rd sentence of my 2nd paragraph. So it's a very simple, straightforward argument. And then the last step of the argument flow is to identify the law. And this is where it gets interesting, because now look at the party B law. It's different. Here in party B law, we say under the 4th Amendment, constitutional reasonableness of a traffic stop does not depend on the motivation of the officer involved or the petty nature of the offense charged, as long as state law permits an arrest. So now what I want you to notice is the difference between party A's law and party B's law. They are making different arguments, but supported by different rules of law. Party A, the suspect, says, hey, 4th Amendment, warrantless stops. Party B says, doesn't matter. Traffic stops can be made as long as state law permits an arrest. All right, Megan, you got any comments on that structure?
No, that's great.
Okay, to me, this makes perfect sense. It's just a nice logical chain of events, and I hope those of you that are watching live are following along with us. But it's not the only way to do this argument type, and so we want to show you something a little different. Megan teaches what's called a funnel approach to this same kind of argument. So Megan, I'm going to let you carry this. I'll just start with the first slide and you go ahead and explain it.
Yeah. What I do is I think of it like a funnel. This doesn't always work, but oftentimes on the bar exam, they like to test the exception or the narrowing of a rule. And so when you see that, I always say start with the broad law and then move to the more narrow exception, the twist, right? Just like you think of it like a funnel. So here I would also start with suspect, but not because they are the criminal defendant in this or anything like that, but I would start just because they have the broad principle of law, which is can't stop without a warrant under the Fourth Amendment. So I would do the same. Notice these are the same words that Jackson used. It's just a different way of thinking about it. So I would start with the suspect arguing that this was a pretextual stop and not allowed, then give the law that supports that. And then I would move into the officer's argument, which is a more narrowing, it's a narrowing of that general law that warrantless stops are not allowed, which is if the state law allows for the stop and the arrest for a traffic violation, then it is an exception to that general rule. Okay. And then I would give the law that supports the officer's argument. So if that makes sense, it's really the exact same thing that Jackson did, but it's thinking of it. We were laughing. He thinks of it horizontally and I think of it vertically, right? So
yeah, and I'm pretty impressed with this, I have to say. I know Megan teaches it this way, and we had a spirited conversation as we were going through this, in which Megan tried to help me understand this even better. And I love it, actually, as I'm looking at it, because that's really, if you look at it here visually, you can see that's exactly what Megan was describing. As we get down near the bottom of her funnel, of her pyramid, this is where the detail really comes in. We've gone from this very general law up at the top to really narrow and specific at the bottom. And I think if that helps you think about a problem, by all means, go for it, because I'm guessing a lot of people, Megan, are looking at this going, yeah, she's way better on this than he is. This makes a lot more sense. I take the simpler approach, but this actually works really well. And so if you're trying to figure out how to craft your second paragraph, this is a good way to think about it. Go general at the beginning. So whichever party's got the more general argument, start there and then work your way down to the narrow. So if we'd had a general argument from the state, we would have started with that, even though I would normally start with the party that's got the burden to prove the point. So two really interesting approaches give you the same writing, but just a different way of thinking about them, right?
Exactly.
Great.
So whatever makes the most sense to you guys as the writers, go with that.
And who says we're not flexible? All right. Now, that's type one of an argument. Hope that makes sense. That's the most common. It's the biggest. It's usually worth 25% of an essay answer, or 25%. So it's a big part. All right. Now we come to type two. And again, I'm going to show it to you in my form, which is that we start with party A's argument. And here we're going to talk about the argument or the call of the question having to do with the Sixth Amendment. This was the part where suspect would argue that he revoked his waiver of an attorney during the investigation when he said, I'm not sure about this, maybe I need a lawyer. This is party A's basic argument here. And again, we're just setting it up factually. So that's the argument. Now we get to the law, but notice that the law we're going to use here is the same law for both parties. We don't have two different rules of law. We're not doing some narrowing of the general rule, but we're giving a rule that both parties are going to rely on. And our law is this: if an arrestee makes an unambiguous and unequivocal request or demand for an attorney, then the police have to cease or stop interrogation and honor the request. Not much dispute about that. That is the law. That's the Sixth Amendment. We could call it the Sixth Amendment and say that, but essentially that's what we're talking about. It has to be unambiguous and unequivocal. So now what do we do after we've given the argument and the law that we think both parties are going to use? We now have party B's argument. The state will argue in this problem that the suspect's statement that he maybe wants an attorney is too ambiguous to require the detective to stop the interrogation. Now look what's happened. We don't need to repeat the rule of law after Party B's argument, because what would it be? The arrestee has to make an unambiguous and unequivocal request for an attorney, right? There's no reason to repeat that a second time. So in that circumstance, you can save time by simply sandwiching the law between Party A's argument and Party B's argument. Megan, you want to comment on that?
Yeah, I think that's a great way of looking at it. Just be careful that you guys are making sure, if you're using this one again, that it is really what that situation calls for and not that you're just getting stuck. And I will say, I talk a lot with students in the personal writing workshop about this kind of stuff. So if you're going through this and you're feeling like, I'm not really sure, how do I identify that? I really struggle with that. Talk to me with the personal writing workshop and we can go through that together, because we spend a lot of time on how you can identify how to put these sorts of arguments together in your law paragraph.
Totally. And I'll just give you the shorthand that I use. If my Party B law starts to look a lot like my Party A's law, I just delete the sentence, because that tells me at that point I'm probably in a type 2 argument. So if that helps, something to keep in mind. Okay. Now, let's go to the type 3 argument in this problem. In type 3 argument, we've got Party A making an argument, and here a suspect will argue that the statement, "No, that cocaine isn't mine," should be excluded from evidence because the statement was made after his arrest, but prior to any Miranda warnings. Okay, so he's saying, I wasn't Mirandized, right? And this is a type 3 argument, so here's what we do. The law is that a person under arrest in custody must first receive Miranda warnings before being subjected to interrogation. That's it. That's the law. And what are the facts? Did he make a statement before he received his Miranda warnings? Yeah, he didn't get the Miranda warnings. What do you do now? Do you write the argument for the state? If so, what would it be? I don't know. He wasn't in custody. No, he was handcuffed. He was in custody. Did he make a voluntary utterance? Maybe, but that seems like a weak argument. So at this point, you're done. You've got the argument and you have the law. Now, I want to remind everybody that we said this is a very uncommon form of an argument. It sometimes flows when you've got just really no dispute at all, and you're just simply laying it out. And it's not worth a whole lot of weight in the overall essay answer. The examiners really here are just asking, do you know the basis of Miranda? They're really setting up the second Miranda problem, which we're not going to go through in this question today. But this is really just a precursor to the big Miranda problem. Would you agree?
Yeah, definitely. So on this one, there's 5 separate conflicts that have to be answered. And so it's less surprising that there might be one that's pretty much get in and get out and move on.
Yeah, and you just don't want to overwrite this. And I think that's really the point we're trying to make here is there's 2 ways you can get hung up on this. One is you could write everything like a type 3 argument. And as we said, that won't work for you. The second is you could be in what should be a type 3 argument and you turn it into a type 1 or a type 2. You make up some kind of frivolous argument for the state, or even worse, you make up a frivolous argument and you make up frivolous law. You don't need that. What you have to be able to do is to look at the problem and say, remember back when they said the 2 Miranda warnings? They're really not testing if you know the Miranda rule twice. There's once here. And then in the second part of the question, they're really asking whether or not you can re-Mirandize somebody in a different setting by a different police officer at a different time, and whether or not that Miranda warning would then be valid. And so really what this argument is doing is it's just giving you a little nudge in that direction. The examiner is saying, okay, we'll give everybody a little gimme here. Is there anybody that doesn't know the Miranda rule? If you watch television, you know the Miranda rule. So this is one of those rare circumstances where you can just write the winning argument and law, and boom, you're done with it. You're out of it and you move on, and you give yourself time for that 4A and 4B, right?
Yeah, exactly.
So there you go. That's the flow. And you can see there's no Party B argument to be made. So there's really nothing to be written there. Okay. Now, there's 3 things to keep in mind when you're writing this law paragraph, as I like to do. The first thing is look for the conflicts. Look for the disputes. If you are thinking about disputes, if you're looking for the arguments, you're going to understand pretty quickly whether or not you've got 2 arguments and 2 rules of law, or 2 arguments and 1 rule of law, or just 1 argument, 1 rule of law. Just keep it simple by looking for the conflicts. The second thing is, in this paragraph, describe the parties' factual arguments. Remember, our first sentence of each of these argument styles was a factual argument. It was not the law, it was just what's happening. And the beauty of that is that now you're taking from the fact pattern and you're just using that, you're recasting it or paraphrasing it, but you don't have to make it up. It's right there for you. So it's very simple. And then the third thing to keep in mind is to ask yourself this very simple question: what would the law have to be to support each argument? Now, if you happen to know the law, if you have this deep knowledge of the law, if you know what Miranda is, great. But if you don't know what the law is, think to yourself, what would the law have to be in order to support the argument? And as you think about that, if the law would have to be different for party A than for party B, guess what? You've got a type 1 argument. If the law would seem to be the same and it's really just an interpretation or application, you have a type 2 argument. And if the law is so obvious that it just is clear what the result would be, you have a type 3 argument. So that's how you can decide the kind of argument that you want to write. And so once you've done that, then again, you write using FLA. So this is our look at this section and this part of the exam and the essay answer. I hope that's helpful. It gives people some ideas about how to analyze and assemble that second paragraph. Next week, what are we going to talk about? The application paragraph? Is that where we're headed?
Yeah, that sounds good.
Okay, so we'll do the anatomy of the application. Ooh, should be fun. So tell all your friends. I think trying to break this out, this is stuff that you and I do all the time, and I think it's second nature to us. It's really been fun, hasn't it, to parse this out and actually articulate what it is that we do unintentionally sometimes, right?
Yeah, definitely. I hope this is making it feel a little bit more manageable for you all as you get back into your studies and start writing all these essays that I know you're writing. I know everyone's just writing right now and not procrastinating on that at all.
That's right. Okay. Great. Thank you very much for being with us. Thank you, Megan, for your insights. With that, we're going to sign off. Hope everybody has a great study week. Good luck to those of you waiting for results in some of the states still out there. And we'll see you all again next week. Bye-bye, everybody.
Thanks for listening and watching the Extra Mile podcast for bar exam takers at celebrationbarreview.com.